Good afternoon, everyone. I'm Judge Michael Davis. You're here in the first appearance court. You're here because you've been arrested, and under the law of the state of Florida, you have the right to see a neutral judge within 24 hours of your arrest. Today, I'm going to be deciding two things. The first is whether there was legal probable cause to arrest you. And the second, if there was, I'll set a reasonable bail or bond in your case if it's applicable under the law. Now, today is not going to be your trial. Today is not the time to talk about the facts of your case. Everything that you're saying is being recorded. Everything that you're saying is being videotaped. And so anything that you say can and may be used against you later on. The things that we may talk about today are things like your community ties and your ability to post a bond. You also have the right to an attorney. Now, the Public Defender's Office will represent each and every one of you today at today's hearing for free. I have a representative there in the main jail, Mr. Romero, and there's also a representative here in my courtroom for the other jails. Also, if you have a private attorney, let me know, and I will try to contact them if they're not here. And actually, speaking of that, we are going to take one case first. It's Tony Curtis Hall. That was a reset from the morning.
Thank you, Judge.
Sure, my pleasure.
Judge Mitch Polley on behalf of Mr. Hall. Judge, presently, I just wanted to point out that Mr. Hall is being held no bond. It's my belief that he is entitled to a bond in this particular case. A few things I want to point out. I filed the motion, actually, we're supposed to be heard tomorrow to have him released. They just filed charges, and I believe it was about on the 55th day, so he should have been released. Unfortunately for Mr. Hall, we had the hurricane, and hence he's been sitting in jail for an extra couple of weeks when he should have had a bond, a few weeks ago. But the one thing I'm asking the court to do, and I know that the state's going to get up here and talk about his prior history. I'm not talking about prior history. I'm talking about this particular offense. This is the offense that's before Your Honor. If you look at it, they're charging him with attempted second-degree murder with a firearm. There's no indicia in the reports of the arrest that he in any way, shape, or form is a principal. And the reason I'm saying that is there's no indicia that he encouraged these people to do this. Apparently there was a beef between a couple of parties. Yes, he's there. I'm not going to dispute that at this particular juncture, but that's what they're showing. And yes, he left. Maybe at the worst case scenario, probable cause would be for an accessory after the fact, Your Honor. But at this particular juncture, the man that stands before you did not pick up a firearm. All the witnesses indicated he did not shoot. There's no indication in any of the reports that are before this court that he said to anybody, shoot, or said that's the person, or we need to get even in any way, shape, or form. That being the case, Judge, I'm asking the court to give a bond in this case. That would be in comport with somebody charged with accessory after the fact. I'm not saying in any way, shape, or form that the state could prove that, but what I'm saying is if I look at the arrest warrant, I look at the reports, that's what I see. And I'm not, obviously, Judge, I'm not you, I'm just giving you my humble opinion. But I've been doing this long enough to understand certain facts and what the state has to prove. I'm asking the court for a bond somewhere in the vicinity of $10,000 to $15,000. He has ties. The state knows that he lives here all his life, and I think that would suffice. They're also going to tell you that he has a DWLS outstanding in Manatee County.
And, Your Honor, I'm just going to, I mean, if frankly, and I appreciate it, but if the state could be allowed to make its own argument.
That's fine.
I understand if the defense wants to bring up mitigating factors, I'll make sure to bring up any aggravating factors I think are relevant.
In any event, Judge, what's before you is what you need to, determine what type of bond should be set. So I'm asking for a $10,000 to $15,000 bond on the facts that are before Your Honor. Not to be redundant, but given the fact it was clear from all the witnesses that testified in front of the detective, this man never picked up a gun, never fired a gun.
Mr. Polley, I'm so sorry. Sir, can I ask you a favor, Mr. Hall? Can you do me a favor? There's a button on that microphone there. It's gonna mute the microphone. That way I can hear your attorney a little better because there's some background noise. Thank you, Hector. I'm so sorry.
Thanks, Hector. That's it. Judge, I made my argument. I'm asking the court for a reasonable bond at this particular juncture. Thank you.
All right, thank you, sir.
Your Honor, I'll start with the bond and release conditions I'm going to be requesting, Your Honor. I'm going to be requesting a $200,000 bond and an order of no victim contact. First, as far as the allegations, I can advise the court When Mr. Hall was arrested, he was arrested pursuant to an arrest warrant for attempted first-degree murder. Judge Zeller was the judge that presided over his first appearance. I can tell you, as an officer of the court, I was present at that hearing. In addition to the affidavit, Detective Scott, who authored the affidavit, was present. The state is not alleging that Mr. Hall was ever in possession of a firearm. We are proceeding, and we have filed second-degree attempted murder charges under the theory that Mr. Hall was a principal. One of the things that Detective Scott testified to at the first appearance is that Mr. Hall was the driver of the BMW that brought both of his co-defendants to the scene where they allegedly opened fire on people at a block party, striking one individual in the head, actually, and then also was the driver of the BMW getting them away from the scene, Your Honor. And the other aggravating factors, Your Honor, include, one, noting his Broward criminal history. And I can advise you, this case is...
I'm sorry to interrupt you,
Yes,
and I want to hear this. I just have a procedural question for either side. It seems we're very far down the road here. He's had a first appearance hearing on first-degree murder, which was later, now it's been charged as second degree. Mr. Pollet has correctly filed an ROR motion, which I assume is set before the division judge.
Your Honor, it looked as though Judge Bober might be able to hear a bond hearing tomorrow. He's in trial. He will not be able to. I checked, I believe, but you correct me, his arraignment isn't scheduled until October.
Late October, Judge.
So-
So when I called over to Pam, they asked that we leave it on with Your Honor.
Yeah.
That was going to be my question, because I
I thought you got that information,
no,
Judge, and I apologize.
I didn't know. No, that's okay. I didn't know, and I didn't have the benefit of hearing the detective's
And Your Honor, and
testimony,
Mr.
so-
Pillay contacted my office and advised us that, yes, it's Judge Bober's desire that it be heard here.
Then that's it. No, that makes total sense. Now I understand. All right. I'm sorry, Mr. Linder.
That's
Go
okay,
ahead.
Your Honor. Your Honor, so this case has been transferred to Rockport. I've been advised that Mr. Hall is going to be HO, habitual offender qualified. That is as a result of, in 2012, he was convicted of trafficking cocaine and possession of drug paraphernalia. In 2010, he also had out of Broward a possession of cocaine where he violated probation. Your Honor, I have, checking CCIS I've seen, and I actually spoke with the ASA in Manatee County. Regardless of what bond the court sets, and I've also been advised by a confinement status, Mr. Hall's not going to be released, even if he posts his bond. A motion to revoke bond on a felony DWLS in Manatee County was filed and granted by his judge with a no bond hold set on that. Additionally, Your Honor, I would note other aggravating factors. It is mentioned in the affidavit that Mr. Hall is an associate of a local gang. I spoke with Detective Vitale of Broward Sheriff's Office of their gang unit. He has confirmed he's familiar with Mr. Hall. He is an associate of this gang. I also spoke with the Detective Peterson of Broward Sheriff's Office. He's in their Viper unit, but he was a former gang unit detective who is familiar with this particular gang. Information that he provided me about this gang that I think is relevant, Your Honor. They are known, and particularly in the past few years, for violence involving shootings and narcotics. They are also known.
Judge, my only objection would be that there's no indicia that my client's involved in any of this. I mean, we could talk about gang affiliation, gang memberships, but where are we showing that Mr. Hall was involved?
Your
I mean,
Honor,
this is nothing but inflammatory.
it's mentioned, I believe, in the warrant, Your Honor, that all three, by a witness, that these defendants are known to, that they are all associates and/or members of this particular gang.
Let me ask another procedural question. And Mr. Linder, it sounds like, so you've had some contact with Manatee County.
Yes.
Okay. What is Manatee County's intention? Is it their intention that if he bonds out, if Mr. Hall bonds out on this charge, is it their intention to immediately extradite him to Manatee County?
See, here's the thing, it's not really extradition when it's from one county to another.
Right.
I don't know exactly, that's really between the law enforcement agencies. I don't know exactly how that works. If, with the no bond hold, if he'll stay here until this case is resolved or not, or if he'll be brought to Manatee County on that case. Your Honor, there's other information with regards to his current criminal charges. If we could just, and I just don't want to lose my train of thought.
I keep interrupting you, it's my fault, so I'm sorry about that.
It's okay, but I guess Mr. Pillai's objected, I believe it is relevant for bond purposes. It's not a probable cause issue, it's a bond issue, and there is allegations in the the sworn affidavit.
He's allegedly involved in a gang, which is a violent entity, involved in drugs and violence, things like that. That's the allegation.
Okay, Your Honor, now, one, I know, additionally, Mr. Hall has 2 open felony cases in Sarasota County.
Okay.
These involve, in one case, a total of 19 charges, obtaining controlled substance by fraud, forgery, fraudulent use of personal identification information. In both cases, this is relevant for 2 reasons. One, I've spoken with the prosecutor on that case. Trying to see if his name is in the system here. And his name is, I'm sorry. William Sturbinski. He was not aware of this arrest for attempted murder. He advised me he is now going to be proceeding with filing a motion to revoke his bond or release conditions on those 2 cases. What is also relevant on those cases, in connection with this, his association with this gang, Your Honor, is one of the other things this gang is known for is going out of the area. There's been documented cases that they've gone as far as New York and Boston to break into cars, steal people's documents regarding their ID, and commit acts of identity.
The only thing I want to point out, and I don't mean to interrupt Mr. Linder, is I'm involved in that case, and there is no indicia of any evidence that he was involved in a gang in that particular offense. The prosecutor never alleged that, never brought that in front of a judge. That allegation has never come up. It's never been in a police report. Again, it's just, purely inflammatory.
If I may, Your Honor, it is relevant considering the information I've given you, considering he's been charged in multiple counts of fraudulent use of personal identification information. Frankly, and I spoke to Mr. Sturbinski, he was not aware. I wouldn't expect an ASA in Sarasota County to know about a potential defendant's affiliations in entirely another county. But it has been I have been advised by a gang unit detective that knows him that he is an associate. They are known to be committing acts of identity theft in other areas. He is facing charges in an outside area for identity theft. It's certainly relevant. And the reason I bring that up, Your Honor, is Mr. Hall is a danger to this community. He poses a threat to other communities. So I think the bonds I'm requesting in the totality of the circumstances are reasonable, Your Honor.
Judge, the last thing I want to say, if you don't mind, is if you look at the last page of the affidavit, the detective Detective Scott, who's doing the affidavit, talks about the identification of the shooters, people's involvement. And it's really interesting. At the end, the last sentence that he actually states is, your affiant believes that he had participated in the attempted murder. He's not sure. He doesn't have any, physical evidence. He doesn't have any testimonial evidence that he participated. It's a mere allegation, Judge. And that's why I'm asking this court to give Mr. Hall a reasonable bond. All the other things, the driving on a suspended license in Manatee County, it's my humble belief, Judge, that those are not relevant to the bond in this particular case, given what you have before Your Honor, Judge. And I'm asking for a reasonable bond, that's all, Judge.
And Your Honor, I would just note this one thing. Your Honor, I've seen many warrant affidavits, many detectives believes because he wasn't there. He believes it based on what he's been advised. That's just the choice. It isn't indicative of Detective Scott's doubts about the case. He felt strongly enough to go to a judge, and that judge felt there was enough to sign the warrant, and then upon reviewing it, the state attorney's office felt there was enough to file a charge.
I think that both attorneys have done a very good and professional job in this bond hearing. There's a lot of contentious and interesting issues, legally speaking and factually speaking, and I think that you've both argued very well and professionally, and the court appreciates that. Mr. Hall, my concern with you has less to do with the nature of the offense, although that, of course, is concerning and it's a violent offense. My concern is you have a lot of things going on right now in terms of different cases in different places. And my job as the bond court judge today is to make sure that you come back to court. Now, you have quite a lot of reasons to potentially flee the jurisdiction because you have multiple cases in multiple jurisdictions. So, you know, your attorney is asking me for one type of bond, one amount. The state attorney's office is asking for a very, very, very different number. It's very far apart. I honestly, and Mr. Linder is being very frank with me, he doesn't know whether or not, if I give you a bond, you're still going to be allowed out of custody because it's very possible your bond in Manatee County has already been revoked, and it's very possible that your bond in Sarasota may be revoked as well, and those agencies might seek to have you stay in custody. They may even seek to have you brought up to one of their counties. The answer to that is going to be decided by the state attorney's offices of those counties, so not even your attorney can tell you right now what they're going to do.
That's true, Judge.
What I will do at this time is this. I'm going to set a $75,000 bond, and I'm going to order that if you make that bond and are permitted to be released from jail, in other words, if those other counties do not seek to extradite you right away, I know extradition is the wrong word, but it's the best one I can grab right now, then I'm going to have you placed on a house arrest, which would be pretrial release at level 1. You'll be affixed with a monitoring bracelet on your ankle, and that really, house arrest means house arrest. You're going to stay within the 4 walls of your house. It doesn't mean a backyard. It doesn't mean the front yard. It means the house. And I'm going to order at this time, while you're on pretrial release, as one of your conditions, that you not associate with any known members of the gang known as the Dania Bloods.
And Your Honor, if I may, more specifically, we would ask for that, but also and/or Dania Hot Boys.
Dania Hot Boys, okay. So the Dania Bloods or the Dania Hot Boys, no association with any of those people that are affiliated with that gang. You won't have much time to really affiliate with them anyway because you're going to be at home, except for emergency situations, doctor's appointments, things like that. You would be within the 4 walls of your home. Now again, I don't want you to misconstrue the fact that I'm giving you a monetary bond, a money bond, with the idea that even if you make it, you might be allowed out. It's possible that you might not, so I need you to understand that, okay? Do you understand everything that I've said today? Yeah, you can unmute it. Go ahead.
Yes, Your Honor, I understand.
All right, do you have any questions for me before I conclude?
No, sir.
All right, thank you so much, both counsels.
Your Honor, just also just ask.
Tony, I'll
obviously,
come
for
see you.
No victim contact.
Yes, sir, I'm going to order that you have no contact with the victim. I'm going to order that you have no contact with any of the witnesses in your case. Obviously, your attorney may and shall have contact with the witnesses, but that you won't have any contact. Do you understand?
Understood.
All right, good luck to you, sir. Well done. Thank you both. I really appreciate it.
Thank you, sir.
Judge, thanks for your
All
time.
right, you take
Appreciate
care.
it.
Thank you. Yeah, I've been working on this system. Yeah, oh, yeah.
Say goodbye.
Yeah.
All right, let's start on.
Your Honor, the jail
Yes,
has
sir.
requested if you could call one out of turn.
course.
On page 7, Ramjan Montel Lakater,
Sure.
and he's about 4 from the end of your docket, 4 from the end of your paperwork.
Oh, wow, okay.
Please
And,
approach and hear a main judge.
all right, good afternoon, sir. All right, you're charged with an aggravated battery causing bodily harm. I'm going to find probable cause for that offense, sir. Mr. Linder?
Your Honor, I don't show anything in Broward. Does pretrial have any notes on him outside of Broward County?
No priors? Okay. Mr. Romero?
Judge, Mr. Montel Kadir is 30 years old. He's been residing in South Florida now for 2 years. He relocated down here to Florida. His family lives in North Miami. He was residing with a friend in Davie. He intends, when he's bonded out, if he's bonded out, that he's no longer gonna be living with that friend in Davie, and he's gonna be, living with his family in North Miami. From what he informed me, Judge, he has, this is his first arrest ever. As far as work, we were talking about this, it sounds really interesting. He works as a gamer. He tests video games for PlayStation and gets paid monthly. Last month he got paid $500, and every paycheck fluctuates, so.
It's a good
I
job.
couldn't give you an average, but, he told me he made $500 last month.
Huh?
He wants to contact his family in order to post his bond, however, he doesn't have their phone number memorized. He does have his phone and property, so I'd ask you to sign an order allowing him access to his phone contacts. Judge, would I be requesting somewhere in the neighborhood of around $2,500 on Mr. Montel Kadir's behalf?
Okay. All right, I'm gonna sign that phone order. This is a pretty severe allegation. It's good that you have no prior records, sir. That's good. I'm trying to reconcile the facts that are in this affidavit with the person that I'm seeing before me today. I'm gonna set a $7,500 bond. I'm going to order that you have no contact of any kind with the victim in this case. You're going to stay 500, that's Lawrence Barrett. You're going to stay you're going to stay 500 feet away from him, his property, his place of work. You can't call, text, write, email, or try to find him on social media in any way. Do you understand that?
Yes, sir.
All right. Good luck to you, sir. Take care. All right. Santia Davis.
I've been informed she bonded, Judge?
All right, I'll find probable cause. Vivian Lang.
North Broward, Your
Honor. All righty. All right, good afternoon, Ms. Lang. You're charged with 2 counts of battery. I'm going to find probable cause for the batteries. Does she have any priors?
I don't have anything, Your Honor.
All right, let's just make it $1,000 ROR count.
If I may, Judge, Miss
yeah.
Miss Liang has been living in Florida pretty much her entire life. She does have family here, including 5 children, ages 16 through 11. She is on disability, so she is not working. She's been living in the same residence since February. Where this incident took place is actually her residence. She indicated to me she can stay with a friend until the victims leave that place, and that she will not go back there or have any contact with them while this case is pending. She's given me the phone number of the friend that she would stay with. I'm going to contact him. She does not think that he's going to be able to make a $2,000 bond. I'd ask the court, in light of her lack of a prior record and her length and ties to the community, that the court consider a $500 bond on each count.
Oh, I thought you heard me. I cut it to 1,000 on one and ROR the second.
Well, then I'd be asking for a $250 bond.
All right. Ma'am, you're going to have no contact with the alleged victim in the case. Victims, don't call, text, write, email, or try to find them in any way on social media, and stay 500 feet away, okay?
Okay, but when is they gonna be vacating my house? I've been asking to leave ever since Sunday.
Right.
Don't discuss the facts of the case, Vivian. I'll
I
call
don't know.
Mr. Jones and see if he can come and get you, okay?
Okay,
All right, meanwhile, take care.
All right, you take care of yourself. Take care.
thank you.
Go ahead and have a sit down, Judge.
All right, Nicole Clark.
I've been advised she bonded.
She bonded? Okay. That's probable cause on that. Melinda Peterson.
She bonded also, Your Honor.
All right, I'll find probable cause. Scott Coy.
That's a medical reset.
Okay.
North Broward's completed.
Oh, thank you, Deputy. Great. I'll see you tomorrow. Frank Botella.
Mr. Botella's here present at me, he's approaching.
Already.
Judge, Mr. Botella did advise me that his mother will be posting his bond.
Okay, very good. All right, then, sir, I'm going to find probable cause for the offenses, and bond will be set total $2,500, sir, okay? All right, good luck. Isaac Exumat.
Come on up, sir.
All right,
Good morning, Your Honor.
good morning, good afternoon, sir. You're charged with violating your felony probation. I'm going to find probable cause for that violation. At this time, you're going to be held without bond. You're going to see your division judge for a violation hearing October 2nd, 8:45 a.m., okay? Good luck to you. You take care of yourself.
Okay, Your Honor.
All right, Marlon Giles.
Mr. Giles? Mr. Giles? He's approaching, Judge.
Alrighty. All right, good afternoon, Mr. Giles. Sir, you're charged with 2 counts of possession of a forged driver's license or identification, driving with a suspended license, a second offense, an expired tag less than 6 months, improper tinting, bringing methamphetamine into the state, and a probation or community control violation. I'm going to find probable cause.
Your Honor, I think count 6 is supposed to be into a detention facility.
Oh, into it.
Yeah, that's what I thought too. I made that
I know, I was thinking, I never saw that charge before, to 10.
Yeah, you
Right,
don't see it
state
often.
Facility. Okay. And, so, sir, I'm finding probable cause. Bond on counts 1 and 2 will be $1,000 each. Count 1 is $100. There's no monetary charge on counts 4 and 5. Count 6 will be a $3,500 bond, and there is no bond.
And Your Honor, frankly, I don't believe bring contraband into a detention facility is a secondary felony. If your court wants to reduce the bond, I have no objection.
All right, thank you for your candor, Mr. Linder. We'll make that a $500 bond. And there's no bond on count 7, sir. That's the probation violation, and you'll see your division judge on the 3rd of October, 8:30 a.m. to address that. All right, good luck to you, sir. You take care.
Good luck, sir.
You're getting this down pretty good. You're getting it down pretty good. All right.
Mr. Lubin?
All right, good morning, Mr. Lubin. I'm sorry, good afternoon. You're charged with grand theft between $300,000 and $5,000 and 2 counts of violating your probation or community control. I'm going to find probable cause for the offenses. Bond on count 1 will be $1,000, and there is no bond on counts 2 and 3. You will see your division judge this week, the 28th of September at 8:30 a.m. for a violation hearing.
Judge, I didn't see an amount on count 1 to differentiate it between a grand theft and a petty theft. I mean, I know he's not going anywhere anyway until he
Right.
goes in front of his division judge. Nevertheless, I feel I'd be remiss if I didn't make that argument.
You are correct. On both counts, I don't see an amount here. Mr. Linder,
Who's this on, Your Honor?
this is Mr. Lubin, Wendy Lubin.
Okay, so it's just on the 1 count, okay. That's fine.
All right, so I'm going to find probable cause for petty theft. All right. And that's a $100 bond. All right, good luck to you, sir.
Thank you,
Take
Judge.
care. All right. Jonathan Berora?
Mr. Burrow, come on up, please.
All right, good afternoon, sir. Let's see, you're charged with possession of burglar's tools. The charge on count 2 is burglary of an unoccupied dwelling. That's an attempt, as I read it. And count 3 is petty theft.
No, Your Honor, it's, one moment. Actually, I would argue that I believe it's, a burglary of a structure. It says he entered the curtilage area of the apartment complex and I would argue he had with an intent to commit a crime therein. He clearly didn't have permission to enter.
That's true. This did happen within the curtilage of an apartment complex. All right. I'll find probable cause then for burglary of an unoccupied structure.
The defendant is currently being supervised by pretrial services in case 17-9118 CF10A for 1 count of felony criminal mischief Based on the court's finding of probable cause, we ask that his pretrial status be revoked at this time.
Okay, so ordered. I'm gonna revoke the pretrial status in case 17911 CF10A. Sir, you're gonna have to see your division judge for a bond on that case. We'll make it $1,000 on count 1, $1,000 on count 2, and $25 on count 3.
And, Your Honor, we would just ask, should, Mr. Barreau be released at some point that he not return to the, apartment complex, noted in this, in the report?
Okay, that's so ordered.
Judge, this may be academic. I know Your Honor went ahead and revoked, and he's gonna be held no bond on the previous case. However, I was trying to remember the probable cause affidavit in reference to this. I believe what it mentioned was he was accompanied by 2 other individuals inside a complex. Inside this complex, it never once stated that he was there without permission. He could have been, one of his friends could have resided there or anything like that. Facts were really like kind of scarce as to that point. So right now we're assuming that he didn't have permission to be in that complex. Second issue would be as to count 3, the petty theft. I don't think he ever actually took the bike. He attempted to, I believe, cut the chain. Witnesses saw him, and then he stopped his endeavor. So I don't think the owner of that bike at any time was temporarily or permanently deprived of his property. So I don't think there's probable cause for count 3. I do not think there's probable cause for count 2. But like I said, at the end of the day, you did revoke the bond because you at least found probable cause on count 1.
And, Your Honor, if I could briefly just start with the easy argument first. For theft, attempting, as a matter of fact, I'm glad that Mr. Romero used the word endeavor, because that's the statute, the language that's used in the statute, whoever takes or endeavors to take. So attempted theft in Florida is theft.
But Judge, you have to temporarily or permanently deprive the person of their property. It could be for a second, it could be for 10 minutes, we don't know. At no point was the owner ever deprived of their property.
It's, Your Honor, it says endeavor. He endeavored to steal it. I think there's enough for theft here, 1. 2, as far as whether he had permission, when given an explanation why he was there, he didn't say, "Oh, my friends had me here." He said initially, where is it?
At that time, we're
Excuse me, Mr. Romero, excuse me, I didn't interrupt you once. Initially, the defendant stated that he was in the area to smoke marijuana and just happened to sit on the stairs. He wasn't there visiting friends, he wasn't there anyone, it's clear in the report. It would appear for probable cause purposes that no one had given him permission to go into this complex, Your Honor.
What does the statute say regarding the petty theft? It says,
One moment, Your Honor.
thank you.
A person commits theft if he or she knowingly obtains or uses or endeavors to obtain or to use the property of another with intent to either temporarily or permanently deprive. You don't have to temporarily, you just have to intend to.
All right, then I'm gonna find probable cause for all the offenses then, but it's a good argument, Mr. Romero, and the bonds will be as they are. Good luck to you, sir. You take care of yourself.
Yes, sir.
All right, Lindale Givens.
Mr. Givens, come on up, please.
All right, hi, Mr. Givens. You're charged with possession of cocaine, possession of drug paraphernalia, and a trespass. I'm gonna find probable cause for the offenses, and, sir, I'll keep the bond at $1,000. There's no monetary charge on counts 2 and 3. All right?
Judge, in reference to Mr. Givens, he advised he's not working, he's homeless financially, has no money to post the bond. We'd be asking you to consider an ROR. I know count 1, it's a residue case. We're just asking you to consider an ROR.
All right. I understand. I appreciate it. I'm gonna deny that for right now. Sir, do you wanna go to the SAP program, the drug treatment program in the jail?
No.
Okay. All right, just based on the probable cause affidavit, if any of these facts are true, it sounds like, well, never mind. All right, good luck to you, sir. You take care of yourself. Randall Gordon?
That's
He's
gonna be-
alone.
reset.
Medical reset? Okay. Shaheim White?
Bonded, Judge?
All right, find probable cause. And Frederick Smith.
Mr. Smith, come on up.
All right, good afternoon, Mr. Smith. This is a change of charge from burglary of a dwelling structure causing damage to burglary of an unoccupied structure.
Your Honor, the bond was $5,000 on a level 1 GPS.
5,000, level 1, okay.
Your Honor, just if I could,
That's what the bond was initially at first appearance.
and,
That was what it was, yeah.
and Your Honor, I can tell you, one, and I'm looking at the original findings, the court did find PC, because when he was charged, it was actually burglary of a dwelling or structure causing over 1,000 damage. The court found PC for burglary of a structure,
Right.
and so the
And it's now
change from
charged.
structured dwelling is not significant.
Right.
And, I mean, I don't know, frankly, I don't know if the state was seeking no bond or if, and the court denied it, but a bond was set on the PBL at that time. I would just ask that the $5,000 bond be kept in place.
Yeah, I'm gonna keep that in place. And you're gonna see Judge Fine this week anyway, sir, on the 28th at 8:45. He's your,
Put it back on GPS.
yeah, you can put it same as it was, and then Judge Fine will make a decision ultimately if he wants to
Thank you.
keep that. But you're gonna see him on the 28th, which is Thursday, at 8:45 a.m., okay? All right, good luck to you, sir. You take care. Herbie, come on up here, Herbie. I saw you sitting there, buddy.
How you doing, Judge Davis?
I'm good. How have you been?
I've been all right, a few ups and downs,
What's his
but I've been
name,
okay.
All right,
So-
you look good. You've been in.
Thank you.
You've been in for a few days.
6 days.
Yeah, I know. 6 days. That's a lot. You've been staying out of trouble, more or less, a little bit.
More or less, yes, sir, this is always
say,
it, there's never anything else.
All right.
More, less than more.
You know, I really enjoyed my time doing first appearance, and you're one of the people that I think about. There's several people that came back a lot, and I think about everybody that used to come back a lot. And I'm not glad to see you in jail, but I'm glad that we got a chance to catch up and make sure that you're okay and that you're healthy. I guess you probably dried out after 6 days, so maybe keep it up if you can. And just stay safe out there, okay?
Okay,
All right, let's do a no contest and withhold and pay those court costs, okay?
okay, I just have one question.
Yes, sir, Herbie.
I had a court date set for a panhandling charge September 11th, but because of the hurricane, court was canceled. Now, I just wanna make sure that my court date didn't come up in the last 6 days, and I have a warrant.
Right, you don't want another warrant. If we can find it for you, I can take care of that for you also, the same. We'll make it a 2-for-1 sale.
Yeah, I just wanna make sure, this way.
You know what judge it was that you have to be in front of? Do you remember?
No, it was, courtroom 1A in the Deerfield,
Oh, it was up
Satellite
North
courthouse.
Broward, up in North, okay.
I mean, I'm sure it hasn't come up that quick because, September, it was just last week, the hurricane.
Hang on one second, let's see if we can find it. He's got 3? Oh, I didn't realize that. Oh, I see, 1 to 3. No, we'll waive it on 2 and 3. So just court costs on that count 1. Let me see if I can find the case in the system.
It looks like he's got an arraignment on October 9th on an obstruction. Basically, looks like a panhandling. Does that sound right to you, Mr. Crisell?
That's probably, that's up in North
Okay.
Broward.
Yes,
All right,
and
you got the case number?
I do. It's 1704-2148
Why does this guy have another
TC 20A.
Oh, they charged
St.
it as a
Louis, yes,
traffic
the second
instead of
second, it was
a.
already
Yeah, they did, because it's obstructing traffic, I guess it technically is what
Right.
they arrested him for.
All right, let's take care of that case for him today too. 17-042-148 TC 20A.
It's a pedestrian obstructing traffic and no permit to solicit. You need the statute number?
And you know I always ask you this every time I see you, but is there anything that I can do for you? Do you want me to get you into a shelter or something?
To be honest with you, on the day that I was arrested for this on Thursday, half an hour before the officer arrested me, I had gotten on the phone with my father, and he's working on, I guess, on his wife, my stepmother,
Right.
to allow me to come back home to Tampa.
Okay.
I don't know how much this is gonna help me, but, you know, I'm just gonna tell him the truth that in the meantime, I needed to, you know,
Yeah, I hear you.
to survive, and I'm not gonna go steal or do anything else, so
All right.
if he could hurry it up with her, the faster the better.
You're a Puerto Rican, right? I remember that. You got any family that got hit by the hurricane?
Yes, my mother's brothers and sisters, I got about 8 uncles and aunts in Puerto Rico.
Well, I'm sending
Close
prayers.
to San Juan that she still hasn't heard from.
I just sending prayers. I hope everyone's okay.
Thank you, Judge Davis. You're always kind to me. I appreciate it.
Well, I'm just sorry you're in a tough spot, and I hope that your dad will take you back home. I really do.
Things are getting better, man. I feel like things are gonna get better.
Good. I'm glad. All right, Herbie, go ahead and raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, go ahead and put your hand down. You're charged with really 4 counts of panhandling, 2 separate cases. Do you want to plead no contest to those charges?
Yes, I would.
All right, you've done 6 days in the county jail. I think that's an appropriate sentence, probably too much, but you understand that by pleading no contest, case is going to be over, there's no appeal, there's no right to a jury trial, case will be done, right?
Yes, sir.
All right, I'm going to accept your plea, Herbie, and we'll take care of cases 17851 MO10A and 1704214 TC20A, so you don't have to go to the Deerfield Courthouse, you're all set on that. And just good luck and stay safe, okay?
All right, it was good to see you, Judge Davis.
All right, you too, Herbie. You take care of yourself.
Take care of yourself.
God bless. You too.
All right.
I'm sorry, Tanya? Oh, yeah, so withhold on all.
Thank you.
All right, no, anybody else in Maine?
Patrice, could you check to see if you could open
Thank
those
you,
files I
Deputy.
sent you?
Oh, Hector's in Maine. Thank you, Hector. I'll see you tomorrow. All right, now let's see. Let's go over to North Broward's done. How about Conti? All right. How we
I
doing?
got them all. Once again, everybody's here.
Oh, you got them all. Oh, okay. All
Where the
right.
party's at?
All right, let me call him, I guess, just in the order I got. How about Alexander Lewis?
Okay. Come on. 1 second, sir.
All righty. All right, if you have him lined up and you want to send him in your order, that's okay with me too.
Okay, that'll work.
Yeah.
Hi,
No,
sir. How
but-
are you? What's your name, sir?
Alexander Lewis?
You are Alexander Lewis. Okay. All right. You have been in for 18 days on a
Well,
trespass.
Your Honor, I'm gonna ask that this go to division.
Yes.
This is actually Mr. Lewis's 3rd look. He had a 2nd look last week. I'd asked the court to look at his probable cause affidavit on Odyssey. The allegations are the reason it was not resolved or nothing was done. It's not your usual trespass situation.
I'm okay with it
Can you
going.
please tell me what kind of situation my trespass is going to resolve into?
I can't tell you today how it's going to resolve.
And Your Honor, I can advise you, the charges have been filed. He's
Yeah.
in Judge Carpenter Toy's division, so he'll
Carpenter
be going
Toy.
for arraignment in front of Judge Carpenter Toy.
All
Well,
right.
that is separate from this division, right?
So this is not a division. There's different judges in this division every week. We all
Okay.
share. What we're doing here is just
But,
hearing your first
Your
appearance.
Honor, Your Honor.
Yes, sir.
I just want to say, how can you trespass at a shelter during a storm?
Some
I need-
questions, I'll give you an answer.
Sir, I'm gonna.
I really would encourage you not to mention anything about the facts of your case or admit that you were there or anything along those lines if I were you, Ms. Lewis.
Not to be on that side.
I was also registered at the shelter.
Well, and then, yeah, without going to the, 'cause
So we're not gonna talk about the facts of your case, but you're gonna see Judge Carpenter Toy in a few days. She's a really fair and wonderful judge. She's a good friend of mine. And she's gonna handle your case, sir, and we'll see how things work out. And you have a right to hire the public defender's office, who will represent you at a very low
No,
cost.
I talked to I had a public defender. I talked to him, and he told me that my case would be resolved the next time I went to court, and it wasn't able to be resolved. So I was wondering what is that issue?
They probably didn't realize that you were gonna be coming back to first appearance. I think what he probably meant was it would be resolved, hopefully, when you went to division, which is gonna be Judge Carpenter Toy. So,
So I did went there, and we talked, and and she told me that we didn't get we didn't she told me that I was trespassing at a 7-Eleven, and that case was also incorrect. That was disposed of, and they said I was also trespassed at a speedway.
You're not helping your cause here,
And
Mr.
and
Lewis.
and the girl
He has
that I said who said that I trespassed it didn't throw out the case.
All right. Good.
So that was also that should also be disposed of.
Good luck to you, sir. Deputy, Mr. Lewis is all done for today. Good luck to you, sir. Go ahead. You'll see Judge Carpenter Toy soon. Good luck.
He doesn't have much of a choice.
Thank you, Deputy. I appreciate it. Whoever you've got up next.
Junior Roseman, sir.
I'm so sorry, sir. Tell me your name again.
Junior Roseman.
Junior Roseman. Okay, sir. So you're charged with 2 counts of resisting an officer.
It's not 2 counts of resisting. It's
That's 1 resisting, 1 obstruction.
no. It's
The obstruction
It's,
got dropped.
sir. Nothing, no, it said no charge, it didn't get dropped. He was arrested on 1 count of disorderly conduct,
Oh.
1 count of resisting without violence.
Resolved.
All right. What's his history?
One moment, Your Honor.
2 years ago, I haven't been arrested for like 2
No,
years.
not you, sir. I don't want you to say anything because you have the right to remain silent. You do not have to say anything. I'm just asking the state attorney's office.
Possession of PvP in 2015. Possession of PvP 2015. Possession of electronic weapon or device, resisting without violence, 2014. Resisting without violence, 2013. Delivery of cocaine, 2012. Resisting without and possession of cannabis, 2012.
Okay. All right, you've been in for 5 days, sir. If you want to take a resolution to the case today, I would allow you to plead no contest, and I would find you guilty of the offenses and sentence you to time served and court
Yes, sir.
costs.
Yes, sir.
All right, then go ahead and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead and put your hand down, and please tell me your full name.
Junior Roseman. You want me to tell you the truth?
That's why your hand's up.
The truth would be good. Why, is there something that you've told me so far that's not the truth?
No, I'm telling you what happened about the case.
No,
Why-
No, you don't, you can put your hand down. You can put your hand down. You've indicated to me that you want to take a plea today. The offer that I made was that you could plead no contest.
Yes, sir.
I would find you guilty of the offense based on the facts and the probable cause affidavit, and you would be sentenced to time served, so you get out today, and the case would be over with, and you'd have to pay some court costs. Is that still what you want to do?
Yes, sir.
You understand that by doing that, you're giving up your right to have a trial.
Yes, sir.
Are you under the influence of any drugs, alcohol, or prescription medication that could make it hard for you to understand me today?
No, sir. I've been in jail. No,
Okay.
sir.
All right, sir. All right, I'm going to find your plea to be knowing, intelligent, and voluntary, and I'll withhold adjudication, sentence you to, I'm sorry, I will adjudicate you guilty. I'll sentence you to time served, and you'll have a year to pay the court costs, okay?
Yeah, God bless you, sir.
And you. Good luck to you.
Yes, sir.
All right. Oh, we can waive the costs on two. All right. Hi, sir. What's your name, sir?
My name is Jean-Baptiste Joseph, sir.
All right.
This is a motion to release,
Yes.
Your Honor. The state has now filed an information. Mr. Jean-Baptiste is entitled to release on this charge at this time.
Okay. All right, sir. Your motion for release is going to be granted on this case. You're going to be released on your recognizance.
Only on that case, Your Honor.
Only on that charge.
Has a immigration rule with a judge's order.
Oh, I see. All right. So you're gonna have to go to federal court at some point and see a federal immigration judge about possible deportation. Okay. So you're not gonna be released from jail, but on this case, you will be. Okay.
Okay.
All right, good luck to you, sir. I hope everything works
So now I
out.
gotta wait for immigration, right?
You do, and they may eventually transfer you to a federal facility if they choose to.
Okay.
Right now, you're gonna stay there in Conti, okay?
Okay, no problem.
All right,
Thank you.
all right, good luck. God bless. Hi, sir.
Charles, hey, yes, sir.
I'm doing well, sir. Let's see, Charles, you're charged, what is it, 2 counts of DUI?
It's one count of DUI, one count of DUI property damage. His bond was, on the DUI was set at $500. His bond on the property damage was reduced to $750.
Have you, Patrice's pretrial, spoken to anybody about him? Did you know
Your
him?
Honor, when he came to first appearance, he spoke with his wife.
Uh-huh.
She said she was not letting him out. He needed to stay where he was because he liked
Okay.
That's what she told me. I'm sorry, that's what she told me.
Can you possibly re-interview the wife? I'll put him pending verification. Maybe re-interview the wife, see if she'll take it back.
No, she didn't say she wouldn't take him back, and then she just said she's not bonding him out. She's kind of sick of the drinking.
I get it. I get it.
You know,
Excuse me, Your Honor.
Yes,
she was
sir.
okay with him sitting there.
On that property damage, it was about the property damage for mine.
Wait,
Don't say anything
yeah.
about the facts of the case. Don't put yourself at the scene. These are all things the state has to prove. They have to prove you were there. Well, they would have had to if you didn't just admit it. So don't discuss the facts of your case, all right, Charles?
And just so the court know, I did call just before court started,
Yeah.
because I remember him from first appearance.
Right.
And she didn't answer at that time.
I gotta make sure that your wife is gonna allow you back in the house.
But she says yes.
She says yes, she's gonna let him back in the house. All right, then I'm gonna release him to pretrial. Sir, I'm gonna release you to pretrial, services. You're gonna have to do a drug and alcohol evaluation, okay? And, they might ask you to do some random testing. You can't drink, okay? No drinking. You've been in jail for 5 days, so you're probably, hopefully dried out. So no drinking, and they're gonna test that you're, drinking or not. Now, just in case, you have another place to stay, just in case, if things don't work out at home?
Oh, we still together.
Oh, yeah.
She's just so sad right now.
She's just upset. Okay, I get it. All right.
I talked this morning anyway.
All right, you'll be released in the next few hours. I want you to check in. You have to register with pretrial tomorrow, okay?
Yes.
All right, good luck to you. All right, you take care now.
She said he didn't
All righty.
I'm tired of this.
He has a walker.
Oh, yeah, no problem. No rush.
She has no problem with him. She just not drinking. He gets
Thank you.
Can you come in, just stay right here.
Yeah, Judge, just to let you know, the gentleman coming up, Mr. Chattersing,
Yeah.
Judge Levine transferred his case to Judge Lerner Wren on Friday.
Oh, okay. All right, that's.
You good? You good?
So he hasn't, and they haven't set him yet?
I mean, it was on Friday. They might not have had a chance to set him on Friday, and then, you come back on Monday. And
Say it one more time. Tony? Right, he shouldn't have, yeah, no, he shouldn't have been on this docket. All right, sir, so my colleague, Judge Levine, transferred your case to another very special judge, and she's gonna see you this week. And she might have some ideas for you, how to help you, and some good things, for you to do. So they actually put you here by mistake, and you'll see Judge Lerner Wren hopefully in a few days, if not sooner, okay? All right. God bless you. You take care of yourself. Yeah, just in case. All right.
That's it.
That's great. Thank you, Deputy. I'll see you tomorrow.
I don't need all the, Ponchi doesn't need all the special attention 2 days in a row.
All right.
Spread out the second look. Spread it out.
I'll do my best. I'll do what I can. See ya. All right.